Welcome to We Get Work and the Year Ahead 2025 podcast series. This year, our special report and corresponding podcast series are created to help you move forward steadily, seamlessly, and successfully in a workplace law environment in persistent flux. Jackson Lewis invites you and others at your organization to experience the report's legislative, regulatory, and litigation insights in full at our website, jacksonlewis.com, or listen to the podcast series on whichever platform you turn to for compelling content.
Hello, my name is Joe Lynette. With me is my partner, Catherine Weber. We co-lead the Disability Leave and Health Management Group here at Jackson Lewis, which really covers all compliance issues related to managing injured and ill workers and workers who have an entitlement to leave under various federal, state, and local laws. So we're pleased to be with you today to give you our insights on what we see as the year ahead in 2025. And if 2024 was any indication, Catherine, I think 2025 is really going to be shaping up to be somewhat of the same, but I think an evolution of where we've been the last couple of years. You know, sort of like the space in the disability leave and health management space, Catherine, seems to be so active for many years. It's almost like you ask yourself, well, where do you want to begin, right? When you look at the year ahead. We're in an environment where it's growing increasingly complex on federal, state, and local levels in terms of accommodating employees, leave entitlements, and so forth. So, Catherine, what do you see as the top accommodation issues that employers need to be thinking about in 2025?
Well, Joe, I'm going to give you a package right now. Top 3, PWFA, PWFA, and PWFA, right? I mean, that's where we're going to see all of the action. I shouldn't say all of the action, but we'll see a lot of action with respect to the PWFA. If we look at where we currently are, the PWFA hasn't been around that long, right? It's only turning 2 this year. And I like to refer to the PWFA as entering its terrible 2s, right? I mean, you thought that you had a lot to deal with when it first came out. Well, now we're in the litigation. Right now, we have a situation where the EEOC has filed a handful of different lawsuits against folks. You know, we're starting to see settlements. We're seeing that litigation continue to unfold. And, you know, I think that we'll continue to see more litigation in 2025 around this. And, you know, I think that the common themes that we can see out of the litigation that was filed by the EEOC, there's so many things that employers can do right now to help themselves so that they don't become, you know, the defendant in a PWFA case, whether it's one brought by the EEOC or one brought by a private plaintiff, right? So, you know, really for employers, it's all about making sure that you've brushed up on, you know, what are those predictable assessments that, you know, should be easy to grant and don't, you know, ask for documentation with respect to those predictable assessments, and also lactation. And then we get into the issues of your forms and your process, right? Because the PWFA really stands the process on its head compared to what we have been used to using under the ADA. The forms are different. The process is different. And although we're still looking for ways to help employees continue to perform their jobs and provide reasonable accommodations that don't create undue hardships, it's a totally different game, right? And to help employers with that, we have created a PWFA toolkit at Jackson Lewis. So if anybody needs some help with respect, you know, to a checklist or, you know, a cheat sheet or some forms, just to kind of make sure that you are doing things properly in your organization, just reach out to the Jackson Lewis attorney with whom you currently work, and they're happy to help you. So, Joe, what about you?
Holiday season, Catherine. You're into gift giving. You're into gift giving. You're into gift giving.
So, Joe, what's hot on your list?
Well, a few things, right? I think company return to work initiatives is certainly on high on my list. The use of artificial intelligence in our space in connection with leave, accommodation requests, hiring, and its potential to have a disparate impact on certain groups of employees. Those are certainly two very hot items that I have, and I've been hearing a lot from clients on. In terms of return to work initiatives, 2024 was some major companies announced changes in their, I guess we could call them return to office policies, RTO policies. It's going to trickle its way down, and already has, I think, in many instances, trickled its way down to smaller employers. And the consequence of this, Catherine, and I'm sure you see this as well as I see it, for every employer strategy to get employees back to work either full-time or more frequently, there always seems to be an employee counter strategy that pushing the other way to continue to stay at home. This is a legacy of COVID for sure, right? But now COVID is, COVID is 5 years ago now. It's hard to believe a lot has changed, and a good amount of time has passed. So, a lot of employers and a lot of people are viewing COVID as something in our distant rearview mirror at this point. So it's taking a look at some of the changes that in the workplace that COVID, forced, right, because of that pandemic, and looking at it now as sort of being somewhat, in our pretty much distant rearview mirror. So what we see a lot, or an increasing number, is requests to continue to work from home on the basis of a disability, or in that vein. And a lot of times these are mental health disabilities, anxiety issues, problems with commuting to work. So, we are seeing an increasing number of requests to work from home as an accommodation, essentially a modification of a policy. Employers can have a policy that require employees to work in the office either full time or on a hybrid basis. But sort of the black letter law under the ADA is that a modification of a policy can be a reasonable accommodation, subject to, of course, to undue hardship, and of course the employee has to be able to perform the essential functions, of their job, working from home. So, we are seeing an increase in accommodation requests to work from home as a consequence of more and more employers requiring their employees to work more and more in the office. So that's certainly what I'm seeing a lot of these days. But Catherine, turning it back to you, what else do you think employers should have on their watch list for 2025?
So I think the other issue that we're going to continue to see a lot of requests for accommodation in relates to mental health. There had already been an incredible uptick in individuals who are suffering from some level of a mental health challenge. And I think COVID really exacerbated that, right? And I think it caused a lot of folks who had their mental health challenges relatively under control. It really, kind of rocked everyone's world to that extent. And if you had a mental health challenge, it became that much more difficult, right, to deal with. And I think, if you look at the numbers in terms of the folks in our country who suffer from a mental health challenge, it's pretty staggering. And I think that, we've certainly started to see already a lot of requests for accommodations related to mental health challenges. And sometimes we see requests for accommodations related to individuals who are neurodiverse. And, someone who's neurodiverse may or may not have a disability. And if they don't have a disability, the ADA and comparable state law wouldn't require an accommodation. But if that neurodiversity also is a mental health disability, that would be something that would fall under the ADA, and we would have to engage in the interactive process and look for a reasonable accommodation that doesn't create an undue hardship for the employer. And I think that employers will have to get more comfortable, if you will, in terms of exploring what types of accommodations might work for different individuals. And everyone is so different, right? I mean, we all are, we all think differently. We all work differently. And I think that if you have an employee that has a mental health challenge, the investment in the time and the energy that you can make to help that person be able to perform the essential functions of the job, I mean, it's well worth it. If you can come to together and find, an accommodation that works, really, that's the best of both worlds for everyone. And that's, that is the goal of the employer community, is to make sure that we're giving our employees the tools to do their job without creating those undue hardships or problems for the business. So I think that we're still going to see a lot more requests for accommodation in that space. And I think it's just going to require employers to step back and be creative and think first to themselves, well, how can I do this? Rather than, no, I could never change that. That's not the way we do things, right? I think if you adopt the correct perspective, the likelihood that you'll find a reasonable accommodation that works for everybody in the end is greatly enhanced. So, Joe, anything else on the watch list for 2025?
Look, you can hardly turn on the TV, watch the news, or read a newspaper without hearing the term artificial intelligence. Right? It seems to be ubiquitous. It's all over the news. It's part of the kind of the cultural discourse at this point. And what we mean by artificial intelligence is really a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. So essentially, it's a machine-based system that makes decisions or recommendations, much like we have always done, right? Through our own analysis as humans and looking at facts and circumstances. And the federal government is concerned about the use of AI, particularly in the workplace. The EEOC, a couple of years ago, they announced their AI and algorithmic fairness initiative, alerting kind of the employer community about, one, the benefits of using AI, but also the potential pitfalls of using AI also, and its potential for disparate impact based upon predicted characteristics. So, there are certain types of employment activities that can involve AI, right? Like recruiting, screening, hiring job applicants, monitoring employee activities, assessing productivity, deciding whom to promote or fire. And the EEOC has recognized that employers are going to be using AI, and there's no stopping that. But kind of the message going forward, and I'll talk a little bit about some DOL guidance that was issued this year also, is the same anti-discrimination rules apply. It's the same rules, but different tools, right? The tool here is AI, right? Not a manager or an HR employee making decisions or recommendations in connection with an employee's employment or an applicant's employment. So the same rules apply, but different tools, right? And the risk with AI is that it's a machine-based system. So it is applying the rules given to it through algorithms to make decisions. And the likelihood is that they're going to make that the tool is going to make and replicate its decisions over and over and over, given the same or similar set of circumstances, which means its potential to be efficient is great, but its potential to run afoul of the anti-discrimination laws can also be much greater than when an individual makes that decision. Because when an individual makes the decision, it typically only affects the one person that they're dealing with, or that they're considering. With AI, it's sort of there's no human involved in the decision making. There is a human involved in setting the algorithm and the parameters, but the potential for a more systemic based claim or a class based claim is greater using AI for that reason. Biden, in late 2023, the Biden administration issued an executive order on the safe, secure, and trustworthy development and use of artificial intelligence. And essentially, it's an order that directed all U.S. government agencies to, I guess, for lack of a better word, issue guidance to make clear that employers that deploy AI to monitor employee work must continue to comply with the protections of the law, right? So, following that, the Department of Labor in April of 2024 issued a field assistance bulletin on the application of the FLSA and other fair labor standards on the use of on employers' increasing use of artificial intelligence, and it focused in on certain areas like the use of AI and FMLA and processing leaves. It also focused on AI and nursing employee protections, and this one's not so obvious. And Catherine, I think you've seen this too. We're getting an increasing number of inquiries about the Pump Act and how the PWFA coordinates with the Pump Act, so that employers can comply or ensure they can comply with the requirement to allow reasonable break space and time for nursing. So it's something to think about. How your organization or how employers are using AI to track and make determinations about employee work hours and setting work schedules and assignments, managing break time and so forth, so that you're complying with the requirements of the Pump Act, and also there's many state laws too that protect the right to pump at work, and some are greater than the Pump Act itself, provide greater protection. So it's something that employers need to consider when they're using AI for scheduling purposes, for breaks, for tracking productivity. So this is an area. It's kind of a new area, a pioneering area that employers need to get comfortable with. But the main takeaway from all the agencies that have provided guidance on this is same rules, different tools. And the need for human oversight of the use and deployment of AI. So that's what I'm seeing ahead in 2025, Catherine, and probably this is something that we're going to see every year for the next few years as employers increasingly grapple with how to use AI as a fundamental matter. There's also some paid family and medical leave patterns that we're seeing, right? This year, Alaska, Arkansas, and Missouri had voter initiated laws that have granted a right to paid family and medical leave. These are voter initiatives; these are not legislative enactments. So we'll see. We'll see if that continues to be the trend. It seems to be that the state legislatures don't, for whatever reason, probably political, want to touch that issue and rather leave it up to the voters. And what's interesting is, these are relatively conservative states too. Alaska, Arkansas, and Missouri, and they're the electorate in those states pretty overwhelmingly voted in favor of paid family and medical leave. So it kind of shows you, I think, or is an indication of where we are as a country on paid family and medical leave. right?
Which is interesting, right? I mean, because for years we've been talking about whether or not we should have national paid family medical leave,
Right.
right? And, it seems like, both sides of the house, right? They all agree that, yeah, that'd be a great thing, but they all disagree about how are we going to fund it,
Yeah.
right?
Yeah.
So, some people say that that they don't think that paid family medical leave will come to us during the upcoming administration. I don't know. I think that maybe this will be the administration that does it, just because if for no other reason, we've seen such an increase, in the state leave laws that have been adopted in this area. And, when you think back, Joe, to when some of the states started adopting paid family medical leave, and employers were just losing their minds because they were like, oh my gosh, how am I ever going to, learn how to comply with these 3 laws, right?
Yeah,
And
right.
now we're in a situation where the map is just covered, right?
Yeah.
And we also have our employees that are just covering, the maps because they work remotely, or they're sales folks and they're working out of their homes. So I think that you might actually see some paid family medical leave legislation come out of this next administration. We'll see.
Yeah, there always seems to be a tipping point with these laws, and it's hard to kind of calibrate where that tipping point is. I mean, we saw it with the PWFA, right? They reached a certain moment, historical moment, where while this issue of accommodating pregnant employees had been active among various groups and very active in pushing that, it was only when it reached a certain tipping point where it actually happened. And maybe we're seeing this with paid leave, paid family and medical leave, that enough states are voting in favor of paid family leave that may be a tipping point issue. So that's I think this is what I see in 2025, and we're probably going to be here next year on what employers should be looking at in 2026, and look back and say, wow, that was that was a lot for employers, and maybe we'll see more of the same going forward. So it'll be interesting.
Absolutely, Joe. And, the only thing for sure that we can say about 2025 is that the changes are just going to keep coming, right?
Yeah. Yeah.
And so, the best advice that we can give folks is to make sure that you've got you've really got your eye on the ball, that you're plugged into your different resources, that you're following, our blogs, following the different articles that are out there, and that how things are changing and how things are trending, so that you can stay ahead of the curve and be compliant and, be the employer of choice. And if you take all of those steps, right? If you stay ahead of the curve, if you're watching the trends and how they're unfolding, and you're staying compliant, you will, find yourself better suited to succeed, in whatever area it is that your business works in. And, it sounds complicated, but it's really not. It's just about staying plugged in and staying ahead of the curve. You do those 2 things, you're going to have a great 2025, Joe.
Yes.
All right.
Okay.
Well, we've enjoyed talking to everybody, and we'll be back, I'm sure, next year with the next edition of what we're looking for in 2026.
Thank you for joining us for the Year Ahead 2025 Special Edition podcast series. Please tune in to future episodes where we will continue to tell you not only what's legal, but what is effective. Our We Get Work podcast is available to stream and subscribe on Apple, Spotify, and YouTube, as well as jacksonlewis.com. If you enjoyed these episodes, we encourage you to share any or all of them with your network and leave a review to help others find us. We would love to hear your suggestions for future topics, or if you're interested in being a guest on our show, please reach out to us at wegetwork@jacksonlewis.com. Thank you for tuning in.